And yeah, I'm not going to introduce today's the speakers of the panel. The panel is Technological Challenges to Human Rights in Modern Warfare. And I will directly give the floor to Rahul. Yeah, we're looking forward to the presentation. Yes.
Thank you so much for this opportunity. My name is Rahul, and the reason why I've included my second designation as well is because I genuinely think for an issue as critical and as controversial as autonomous weapons, you have to broaden your dimensions and look at both the political, ethical, and the philosophical dimensions of these weapons. And that is what I do at the center, Mahatma Gandhi Center for Peace Studies, along with my co-teaching at Jindal Law School. So just a brief introduction, and the template that I'm going to follow is mostly the legal paradigms that I'm operating in. Those are visible on the slides, and the examples and the opinions and the analysis that I'm going to deliver so that we can have a more fruitful conversation. So with respect to what are these weapons and why I have categorized them as AWS and not LAWS, the laws, obviously there is a distinction with respect to lethal autonomous weapon systems, which are basically those autonomous weapon systems which have the possibility to kill other human beings. Just because it's mentioned AWS does not mean I'm not including those, because I think that would render it as an academic discussion, because any weapon that uses or reduces or completely eliminates human involvement is an autonomous weapon system, and it's subject to the paradigms of IHL and IHRL. So, and we'll discuss about why these weapon systems are problematic or what are the benefits. But broadly, like the two paradigms that I said I'll be operating in is IHRL and IHL. So jumping right into it. I genuinely think that autonomous weapon systems, and especially their deployment, especially in critical areas and states which have already done so, for instance, South Korea has developed a robot, they deployed it on the North Korean border, the border between the Koreas. The problem with the paradigm is that one, and we've discussed this in various panels, it's difficult to identify who are operating these, if especially non-state actors are operating these, what is their accountability. So I'm not going to go into that analysis, but broadly I'm going to divide it into traditional divisions of IHL and IHRL. Obviously, when I'm looking at IHRL, I look at the right to life, which is the most critical right when it comes to these weapon systems. I'll also interestingly look at the right to privacy and how these weapon systems, especially if they're deployed for a long period of time, how do they conflict with the right to privacy when it comes to surveillance? And also, I look at why, at a fundamental level, at a philosophical level, it contradicts the right to dignity. Obviously not codified, part of UDHR, not a treaty, but very important for analysis that informs generally the human rights. Secondly, I look at the international humanitarian law paradigm, where I'll again give a very traditional framework analysis, which means I'll deal with the three most basic principles: distinction, proportionality, reasonable precautions. And I'll see how each of these are tested against these weapon systems. And finally, I'll try and point out what are the accountability gaps and what we can do to resolve those gaps when it comes to these weapon systems. So coming to the international human rights law paradigm. So we all know that the ICCPR and Article 6 specifically codifies the right to life. What is most important is the analysis that has been followed of this right by subsequent general comments of the HRC, by scholarly analysis. And what is clear is that obviously it does not prevent taking away right to life, but rather arbitrary deprivation of life. But the important analysis is with respect to the dignity aspect, which obviously, like I said, is not a separate human right. But how do you value life and how these weapon systems dehumanize them? The next slide is going to be specifically about right to life, so I'll jump into it. But more broadly, when it comes to human rights, and especially when these weapon systems are, let's say, deployed in peacetime areas. So for instance, keeping aside the controversial nature of the South Korean border, which many say they are technically still at a state of war. The fact is, right now there's peacetime, and if both or either Koreas deploy these weapon systems, they will be subjecting themselves to the human rights law paradigm. And therefore, the two mechanisms, keep the dignity aside, because like I said, it's more philosophical rather than legal, the two most important rights are obviously right to life and right to privacy. So coming to the right to life aspect, we obviously know that this is a non-derogable right. The states do not have permission to take it away, except obviously if it's not arbitrary. But the more important thing is with respect to the nuclear advisory opinion and how that's protected in humanitarian law paradigms as well. So, for example, and this is now a well-settled debate, that the right to life is extended in IHL, though IHL becomes a lex specialis. What is most important when it comes to peacetime is how much force can you utilize or how much force can you deploy in order to use these weapons. Like I said earlier, there are various kinds of autonomous weapon systems. One, those are like fully autonomous, those that are semi-autonomous, those that utilize human involvement, but are mostly autonomous. So I don't want to go into the distinctions of those because that would make the presentation more technical. But when it comes to how much force can be used, we have some soft law mechanisms. For instance, the UN basic principles on the use of force and firearms. Obviously, it's soft law, but it might guide us as to how these weapon systems can be deployed in peacetime areas, if at all they are deployed. Obviously, we have some case law analysis when it comes to ECHR. The reason why I've cited ECHR judgments more than twice is I genuinely think it has been rather more successful of the human rights courts compared to, let's say, the Inter-American Commission or other courts, including the ICJ itself when it comes to specifically human rights analysis. And if you look at the Greece case, while it did not deal obviously with the question of autonomous weapons, the goal or the intention that can be culled out from the case is that lethal force must minimize harm. So the goal has to be minimization of harm. It can never be to win the battle, right? So that's a critical question in my opinion, because if the weapon systems are deployed purely to win battles, and we're right now operating in the peacetime domain, that would blur the distinction between a law and order function versus a traditional conflict function. Obviously, when you're in peacetime areas, the purpose has to be law and order. The purpose has to be to minimize harm rather than actively cause harm. So that is something that autonomous weapon systems, in my opinion, would struggle with, especially if human involvement is direct. And I'll come to the accountability gaps later, but just in terms of the right to life violation arguments. Another important thing, and this is the same problem when it comes to IHL, is the subjective judgment, right? We'll obviously talk about the problems with building these algorithms, the inherent biases, etc. But generally, when it comes to arbitrary deprivation of life, the general comment, obviously, it's not a very comprehensive or exhaustive general comment, but it's a fairly detailed document in that you have 10 pages of some content that you can point out to. It said that arbitrary deprivation of life when subjective judgment is absent. What it essentially means is that you need to have some, if that's the interpretation you want to call out, that you need some human involvement at all times. And therefore, fully autonomous weapon systems would necessarily have that problem. And I'll tell you why I have a philosophical issue with that as well later, but purely in terms of the human rights analysis as well, completely taking away human control, as per at least the general comment, is definitely problematic when it comes to right to life violation. The right to privacy, like I said, again, not something that is intuitive, not something that we generally talk about when it comes to weapon systems, but something that, in my opinion, is relevant for peacetime paradigms. So, for instance, if you imagine a real life situation, let's say right across, let's say in the old town square, you want to have an autonomous weapon system. One thing is fairly clear, that those won't be deployed when actually there are people who need to be targeted. Those will be deployed before that, which means they would necessarily use surveillance as one of the mechanisms. Otherwise, how would you categorize who are the civilians, who are the combatants, etc., or who are the ones who are using force, which these autonomous weapon systems will target. So therefore, and this is what I've at least figured out from the scholarly analysis. I've read many scholars who have specifically talked about right to life, but they've not gone into or forayed into the right to privacy implication for the simple reason that it's not intuitive. But I think it's very important because, especially with states such as India, who are increasingly using digital technologies to surveil over the citizens, if you do not have sufficient algorithm checks and balances, it creates a serious problem when it comes to the right to privacy violation. Now, when it comes to mass surveillance, we know from the ECHR jurisprudence again that mass surveillance generally is problematic. Obviously, like you need to have some security mechanisms. CCTV cameras are almost now ubiquitous, but the fact is, when you deploy these systems, it will necessarily cause mass surveillance, and that is like obviously problematic. And obviously, the other two words, necessity, proportionality, analysis, these are not empty words. Every word means something when it comes to human rights law context. When you talk about necessity, you only have to use that much force, which is necessary to mitigate that harm. But will the autonomous weapons restrict themselves to this? And secondly, who is accountable? Again, we'll deal with the accountability question. But one of the primary misuses could be the lack of accountability. For instance, let's say the central government, talking about, let's say, the Indian context, where it's primarily a unitary system with obviously like federal protection, but by constitutional definition, it's a union of states. If the central government deploys the autonomous weapon systems in peacetime in municipal areas, who is accountable? Is it the local municipal authorities who are supposed to look after the maintenance? Is it the state governments or the central government itself? So these are questions that we'll talk about. But now coming to IHL analysis, which is obviously the more interesting part and which is also the paradigm in which these weapon systems will most often be used. Because at the end of the day, states want to use it to win combats, like real life combats. The primary debate, and we know from the preamble to the Geneva Conventions that if there is no definition, or if there are situations which are not covered by the conventions, they have to be guided by the dictates of public conscience, principles of humanity, etc. And that is something that will be like primarily tested. I'll obviously deal with each of the traditional principles of IHL later. But just on a broader level, when it comes to IHL, the fundamental problem is that one, it did not foresee autonomous weapons, the conventions. And secondly, there is no like development with respect to whether states are willing to now ratify a convention that will like regulate these weapons. And second, if you're really talking about principles of humanity and dictates of public conscience, as the preamble suggests, then I think at a fundamental level, before we delve into the legal analysis, it is problematic because it dehumanizes life generally. I mean, just imagine in the times that we live in, where states are all the more powerful, they have all the mechanisms at place, they can literally place autonomous weapon systems without even losing any soldier side. That is fundamentally and philosophically problematic when it comes to IHL, because the goal of, as at least I would like to believe, of IHL is to, one, if states are engaging in war, to regulate war, to ensure that war is in that sense fair. It's just like they abide by the traditional principles. But how does this play out when the individuals from one side are not involved at all? You just have one side losing personnel. So that's the fundamental debate, which scholars are also like debating whether like these weapon systems are in the first place governed by the IHL mechanism. But assuming that it is, and the fact is that unless we have a new development, we'll have to like test them against the traditional principles. So let's come to the traditional principles. Like I said, I'll deal with the three like traditional principles that govern, that should like govern if these systems operate in IHL. One is distinction. The rule obviously is like fairly clear. Any force that is used during combat must distinguish between civilians and combatants. It should not misidentify. I've cited some scholars. That does not mean like I've not referred to other scholars, just that some which explicitly said what I wanted to say. So those are on the slides. So what we know for sure when it comes to the rule of distinction, and in my opinion, I do not fully agree with the advisory opinion in the nuclear weapons case where it said nuclear weapons can possibly like abide by the principle of distinction. For me, it's logically bizarre, but assuming that the advisory opinion is the case that we have at hand, we know for a fact that it's a rule of customary international law. And the challenges with respect to autonomous weapons, and in my opinion, this is the greatest challenge. One, how do you ensure and who will ensure that the targeting algorithms the data that is fed into these algorithms. That is one, it's collected without any biases. Second, is it like public? Does the public know which data has been used? And thirdly, what are the situations, or what is the methodology used to identify or categorize civilians and combatants? Because let alone the autonomous weapons, even in a real life combat, especially now with the increasing role of non-state actors and civilians being used as human shields, etc., it's extremely difficult, even for like real commanders, like high skilled commanders, to identify, okay, this is a civilian, this is a combatant. So how would an autonomous weapon system deal with this issue? That, in my opinion, is not fairly clear. The states which have like developed like these autonomous weapon systems, or at least the preliminary like models, they obviously say that it fully complies with the rules because the algorithm has checks and balances. In my opinion, that is not a watertight argument, because one, they have not made the data public, which means, I mean, at least the methodology, right? Obviously, for security reasons, they cannot like divulge all the data, but at least what is the methodology used? Does it use the physical characteristics, the color, the way the person is dressed? So, I mean, these are situations that the autonomous weapon systems have to like take into account. Coming to the rule of proportionality, and I'll quickly glide through, keeping in mind the time, but highlighting the essence of my arguments. Again, when it comes to proportionality, obviously codified in the additional protocol, Article 51(5)(b), the challenge really, and I'll jump to the challenge because everyone is aware about the rule of proportionality. The challenge really is how AWS, like autonomous weapon systems, they fundamentally lack the ability to assess which a human would in terms of the subjective judgment. And I'll tell you why that is problematic. I do not contend that humans are foolproof when it comes to their subjective judgment, but at least they take a call, and they take a call based on their gut feeling, their intuition, and then they're held accountable. But when it comes to autonomous weapon systems, you do not have that ability. One, you do not, and this is what actually Professor Harari points out. I read one of his articles in The Economist where he says, AI systems are not sentient. They cannot sense things yet, at least. So in that sense, how can you like engage them when it comes to human lives, right? So that's one of the problems. We have some tests which international courts have laid out. So for instance, in the prosecutor versus Gallic case of International Criminal Tribunal for Yugoslavia, we have the reasonable commander test, where it says a reasonable commander must anticipate excessiveness. So again, it's somewhere referring to the gut feeling, the intuition, like a reasonable commander. And obviously, like if they are held accountable, the courts will take that into account, that given the situation, the commander took a call. But that is absent when it comes to autonomous weapon systems. Another thing, and I've drawn some parallels. So I think one of the reasons why, let's say, booby traps and mines are like banned is because one, there is no like control over where they go. Like there is no way to anticipate damage. So it's completely possible. Let's say you have a mine laid out to tackle, let's say, 10 warships, but only one civilian passes through and it dies, right? So excessive force, you cannot like decide what's the exact amount of force required. That's exactly the problem with autonomous weapon system. And most importantly, and this is given in one of the leading commentaries on the additional protocols, you have to make a case-by-case analysis. Like I was saying about real-life situations, you just cannot build an autonomous weapon system with a consistent algorithm. But okay, these are the situations in which force has to be used. These are the situations in which lethal force has to be used. Simply because there has to be a case-by-case analysis. You deal with every case differently. It's completely possible that you have like 3 different situations with one common element. Let's say all 3 of them carry weapons, like these civilians are carrying weapons, but all 3 of them have different weapons. So is the autonomous weapon system so developed that it can actually determine what is the force that will possibly be used by those civilians? Can it anticipate the force to be used? Because that should be the force that should be used to mitigate that damage, right? So that's a problem with the proportionality analysis. The last one, obviously, very obvious, and you have to abide by them. It has to take like feasible precautions before it deploys arms. Can it do so? How can it do so? And what are the challenges? the main issue is that there's no, and states which are trying to develop fully autonomous weapon systems, they want to develop systems which have absolutely no human control. So basically no oversight. And even if those are like context dependent, let's say they have fed into algorithms a specific context in which force is to be used, states are trying to develop systems in which they have to use no humans at all, which is obviously problematic because when it comes to like feasible precautions, one thing that you need to take into account, and this is the fundamental analysis, is that can you develop autonomous weapon systems which utilize human involvement, but at the same time have the provision of overriding those judgments. So this is another like critical situation or a controversial question, that who should override whom? Should the autonomous weapon system, if a human is involved, override it, or should the human override? Obviously, logically, it seems the human should have the possibility to override, but then it would be a question of why use autonomous weapon systems in the first place if you want a human element. Now let's turn to, like, before I run out of time, turn to the impact of these weapon systems. And I've tried to draw some like parallels. So the Gatling gun, which despite like its good intentions, escalated warfare intensity. And that's a similar problem with autonomous weapon systems. Even if the intention is good, even if, let's say, intention is to actually minimize harms. And we know from ICJ jurisprudence that you have to like take a good faith analysis of states' actions. That first you try and take the analysis in good faith, and then let's say look at the misuse. But even a good faith analysis, and keep the, let's say, benefits aside, that it will reduce military casualties, the fundamental problem is that it will just lower the threshold for initiating conflict. There will absolutely be, and if states increasingly use it, they will use it under the guise of deploying it in peacetime areas, right? So for instance, let's say states which claim that they are not in armed conflicts may just deploy them to say that, okay, we are just here for surveillance. If force is used, then these high-tech weapons should have the ability to mitigate those harms. The problem, like I said again, is that it will just lead to a situation where, one, you're dehumanizing conflicts, you're taking the humans out of the picture, and you're not valuing human lives as you should. And coming to the accountability gaps, one, like I said, I was emphasizing constantly in my presentation, that there's a clear problem with the accountability mechanism, especially when it comes to complicated legal structures such as India, where you have, let's say, a constitutionally structured, three-tiered structure like democracy. The problem really is accountability. How do you attribute, right? And we know that traditional frameworks such as the Articles on State Responsibility, they obviously didn't foresee this. So how would state practice, or how should you interpret state practice to tackle with these attribution issues? Now some like proposals, I genuinely think, and I'll start with the last one, that you need to have a moratorium on these systems unless you have a legal framework in place. There is absolutely no urgency to deploy these without states coming on the table. It may not result in a binding treaty, but some agreement with respect to the use of these weapon systems, right? So at least like you can have a moratorium unless states are on the table. Of course, if they choose to like disagree and they don't come up with an outcome, that's something that states can like choose whether they want to still proceed with, but at least you should have a moratorium until it. Second, and this is what we do in our work at the Mahatma Gandhi Center for Peace Studies, we also look at the political and philosophical dimensions of these systems and generally like these technologies. The problem really is you have to infuse these weapon systems with ethical standards. You just cannot like segregate legal principles from ethical standards when it comes to these systems. And that will be one of the challenges, and that is one of the proposals for reform. Also, like quickly, apart from the obvious that you have to develop a framework, you also, in my opinion, need some human involvement at all times. If states are choosing to deploy these, it just cannot be fully autonomous. Because that, we have discussed the problems, but just when it comes to reforms, at least some involvement, either when it comes to the trigger of the weapon systems or when it comes to the final decision-making ability. While like concluding, I just want to highlight broadly like 2 points. That one, in my opinion, this entire development is synonymous with a general decline in values that we have had in the last 6, 7 decades, at least in India's context. The truth is the age of idealism has declined, and therefore, even if these weapon systems are deployed, you will not have a massive outrage as you should from the civil society, from other governments, the opposition parties. So my issue with these weapon systems is that although they are a novelty, the problem is that they do not take into account what is happening parallelly in the society. And the development of these weapon systems is a result of declining these values. And as far as the legal standards are concerned, I would just like to take your opinions on what are the different mechanisms or different rules that we can use to come up with some scholarly analysis, because at the end of the day, if you want to ensure that states use legal standards, the scholarly analysis has to be right on point for them to find out. Thank you so much.
Thank you so much. So we will continue with Tsvetelina.
Thank you very much. Rahul did the impossible job of going through both human rights law and humanitarian law and outlining all the dynamics. What I've tried to do is to go as narrow as possible with one very specific issue to look at in the context of militarized artificial intelligence. And this is the question of the application of the right to life for members of armed forces who are trained or deployed alongside autonomous weapon systems, and to look at the positive obligations of the deploying state in relation to the safety of those members of armed forces who are deployed alongside autonomous weapons. Now, as you'll see throughout the talk, I'm really picking my battles, so I'm not going to pick the battle on what an autonomous weapon is in terms of definition. I'm also not going to pick any battles in terms of the relationship between international human rights law and humanitarian law, partly because Jindal has already done a fantastic job at looking at the right to life of soldiers. But the reason why I focused on this topic is that typically the discussions on autonomous weapon systems gravitate towards questions of IHL, around distinction, proportionality, precautions, and the general questions about conduct of hostilities rules and the protection of the civilian population. But what is underlying these discussions is a concern around unpredictability, the potential that there is going to be some kind of severance of the event on the side of the party to conflict to the actual battlefield outcome. But this question of unintended engagements is not specific to the civilian population of a particular side. It can also be a concern that arises with those members of armed forces who have boots on the ground and are deployed with these systems. So what is underlying this is the dynamic that Rahul pointed out, which is there is a concern, there is a challenge of unpredictability, but on the other side, you have many potential benefits that come with these systems. And again, not picking any battles, for me, it's very much an empirical question, whether at some point we'll have systems that will be able to do the types of analyses that we have in mind, that might be better at target identification, that might provide less biased ways of assessing collateral damage. So to me, that really is a technology-specific question, which I'm going to leave to the side. But what happens is that within those dynamics of challenges and benefits, we have very specific questions of interpretation of specific obligations under international law. So my focus is specifically on the right to life, and specifically about positive obligations in relation to members of armed forces. And specifically, I'm going to draw from the European Convention on Human Rights jurisprudence by the court. And before I go into the question of interpretation of that right and the obligations, I would like to highlight three dynamics, which I think have been very much prominent in our discussions since yesterday. The first one has to do with mapping out a landscape of relevant obligations. The second one has to do with whether this is something which is a unique question or is something which is just a continuation of past discussions in international law. And then finally, Yael and I have been geeking on methodology since yesterday. So a final point about methodology and how we can use all these statements generated in the context of the discussions on autonomous weapons here. Now, on the question of focusing the conversation, this is not to say that we should reorient this from these questions of IHL, which Magda and I have been writing for 5 or so years already. But it's more to say that we should also look at other types of legal wrongs that have bearing on the safety of these autonomous weapon systems. And here there's a few benefits to thinking about this. The first one is a question of narrative. It might be that even for domestic audiences, it will matter whether you can actually put this in the context of your own sons and daughters who are members of armed forces. So the way in which you think about the safety of those systems in terms of how you appeal to the domestic audience might be a little bit different. There's also a question of procedural mechanisms, and depending, of course, on the human rights treaty that we have in mind, it might be that you have recourse to a court or a body that will be able to review and maybe provide a little bit of specificity on the types of measures that can be taken to mitigate that risk of unpredictability. Now, the second point, which is that conversation unique? And are autonomous weapons bringing some kind of qualitative change? We just had a conference kindly organized by Magda a week ago in The Hague, where many said that they see some kind of qualitative change of the types of risks of autonomous weapons as opposed to other weapons. To me, it's more of a question of autonomous weapons highlighting certain areas that have not necessarily been properly specified before, when it comes to questions of lack of intent, whether it's in IHL or IHRL. So questions of malfunctions, mistakes, they have always been questions that arise in armed conflict. Now it's something that is just coming to much more in the context of autonomous weapons. But you can think of questions of unpredictability that arise even if you're using a bow and arrow. The question of environmental conditions affecting the direction in which it is going to go. The only difference that we might see here is that we're piling up additional metrics in which the unpredictability can go. It might be because of a greater geographical scope or a greater temporal scope of application or some kind of causal chain, which is a little bit longer from human input to actual outcome. But the fact that this is not a unique conversation to autonomous weapons, to me also cuts in the other direction, that we have actually quite a lot to draw from and to analogize. And what I'll be focusing on in this talk is on questions of accidents in the context of dangerous activities, environmental disasters, if you like, road accidents. All of these have been developed in the jurisprudence of the European Court of Human Rights. And I think that something can be learned from it also in the context of autonomous weapons. And the third point is a point about methodology and how we interpret the relevant obligations. And we have seen over the past years a wealth of statements by states, whether it's in the context of cyberspace, and the Cyber Law Toolkit is doing a fantastic job of unifying all of these statements in one place. We're seeing many conversations, working papers in the context of the group of governmental experts on autonomous weapon systems in Geneva. And there's a question of what we make of those and how we treat them. To me, though many states might disagree, they clearly have interpretative relevance as subsequent practice in the interpretation of treaties, and they may also provide evidence of opinion jurists when it comes to customer distinction. It probably will come as absolutely no surprise that there is nothing very specific in those statements when it comes to the interpretation of the right to life. For many reasons, especially the ones developed in the context of the group of governmental experts, they have been very much shaped by the mandate of the group, and they primarily focus on questions of interpretation of international humanitarian law. But what has been generated has been a lot of concrete measures, risk mitigation measures that can be taken. And there is a question of whether we can use and draw some insight from those types of measures in the interpretation of certain types of positive obligations and what states actually owe in the deployment of those systems. So with these 3 points in mind, and going to the right to life, we know that the right to life and the obligations that stem from it are not only looking at the intentional and unlawful deprivation of life, but there are also positive obligations that stem from the right, which are obligations to take appropriate safeguards, appropriate steps to safeguard the lives under the jurisdiction of the state. And the jurisprudence of the European Court of Human Rights has been very prolific on that specific limb. And it has looked primarily in 2 directions, at the provision of some kind of regulatory framework and also taking specific preventive measures in the context of activities that raise an issue. And to show how this operation of the law works in practice, there's a case called Tsvetelina versus Bulgaria, which dealt with the death of a service member from the Bulgarian forces who jumped from a helicopter during training. And due to the speed that the helicopter was going, lack of proper training, he hit his head on the tail of the helicopter, was unconscious, and then he fell straight down. So then there was a question about the positive obligations of the state of Bulgaria, the positive obligations in relation to the training of those forces, in relation to an investigation that would happen at the subsequent stage to establish the facts of what actually happened. And the court said a few things. The first one is that the content of the positive obligation to safeguard life is context specific. The second one is to say that when it comes to members of armed forces, they are inherently engaging in dangerous activities. So jumping off of a helicopter is something which is inherently dangerous, but it's also part of your ordinary job as a service member to actually engage in those activities. But that does not mean that the state does not have obligations to protect your life. And in fact, it is precisely because these are dangerous activities that the state, when it organizes them, or organizes or authorizes them, it actually has to take concrete measures to protect that part. Now, what the court said exactly is that whenever a state undertakes these activities, it must ensure through a system of rules and through sufficient control that the risk to life is reduced to a reasonable minimum. Now, that sounds broad enough, and it leaves quite a bit of a margin of appreciation of the state to decide what types of measures to take precisely. And in different bits of case law, the court has looked at different things that can be done to mitigate such harms. One example in the context of anti-personal landmines in Turkey, in Pasha and Erol versus Turkey. There, the question was about a child that actually ventured into the zone where there were mines and was injured. And the very specific step in that case was to say that the barricade that was made around that zone was actually spaced out in such a way that the children could still go through. So in a very specific context, there will be very specific measures that have to be taken. And then the question is, what does that tell us about the context of deployment of autonomous weapons systems? And the reason why I went to the point of methodology before is because there are a number of different positions that have been submitted by states with concrete procedural measures that they suggest. There are draft articles that were submitted by the UK, US, Australia, Canada, and a bunch of other states to the group of governmental experts on autonomous weapon systems, when they suggest that there are debiasing measures that should be taken, that there are cybersecurity measures that should be taken, that there are questions about mitigating the risk of unintended engagements and loss of control over a system. So going through a full kind of spectrum of different measures that must be in place. They're not saying as a matter of law, but they're saying to ensure that the system is operating as intended, you have to take all of these steps. So it seems to me that this is one way in which we can look at all of those statements that have been generated to actually place them in the context of possible measures under positive obligations on human rights. And the court has consistently affirmed that there is a discretion to states and also that these measures should not impose a disproportionate burden. But even if this is the case, we still see that there is something there to be said about the actual need to take measures to safeguard it. And another type of obligation that stems from the right is a procedural obligation to conduct investigations in cases where there is, even coming from negligence, where there has been a death or a life-threatening situation. So in those cases, something which is interesting from the jurisprudence of the European Court is that it has said that it has to be an investigation capable of establishing the facts. And this might be interesting in the context of autonomous weapons, because one of the main criticisms is that they actually can operate in ways which are not fully understandable, not fully predictable, and not fully traceable. So there is a question about whether this specific standard adopted in the jurisprudence would implicitly mean that there is some kind of degree of traceability that has to be established for these systems to be able for a state to comply with this obligation. And then, before I conclude, there are two additional points that I would like to make. One of them is about when the obligation arises, and the second one is about jurisdiction. When the obligation arises, we actually don't have to have a debt. It can also be in cases where there has been a risk that has emerged. And this is something which has been seen consistently in the jurisprudence of the European Court. That, for example, you can have escaped death by fortuitous circumstances, or even if there is a risk that has already emerged, this is sufficient to say that the state had these obligations and it had to take those measures. And the second one, on the question of jurisdiction, it was already touched upon a little bit in the previous session. There will be a difference of how we think of this if we have members of armed forces who are being trained domestically within the territory of the state, in which case that question of extraterritorial jurisdiction doesn't arise in the first place. So it's very similar to those types of training accidents that we have in the jurisprudence of the court. Now there's going to be a question about deployment of members of armed forces in an extraterritorial context. From the UK Supreme Court, in the case of Smith and Albert versus Ministry of Defense, the court accepted that an issue can arise in those situations of deployment because the state is one that is exercising authority and control with the service members when they are deployed. But even so, just to show that we don't even have to have a context of conflict, we can actually start thinking about these procedural obligations even when those service members are just being trained at home in the off chance to see what can happen with the deployment. And this is not going to be different if we are thinking about the deployment of these systems in relation to law enforcement. It's just a general question of the threat that can arise by deploying them alongside members of armed forces. And to me, this means two things as a conclusion. The first one is that this opens up some scope for legal strategy to actually bring some of these cases to a court and to try to see the types of measures, so to bring some kind of specificity of what these systems have to do. And the second one is really to just get states to actually provide a justification for what they're actually doing. So we're not talking necessarily about saying that these autonomous systems are unlawful to begin with, but some justification to show that you have taken sufficient measures to ensure that you're not taking unjustifiable risks to the life of your service members. And I'm going to stop just before you completely fall asleep.
Sorry, it's relevant talk of after speaking. That was with you.
The body says no, but the mind says
yes. Sounds exciting. It was an action movie dream.
Exactly. Thank you.
So thank you so much to both of you. I already have questions. We have Jan first. Okay, thank you.
So thanks for really two extremely interesting presentations. And I have questions to both of you. Apologies, these are too many questions. Rahul, I have several thoughts because you covered so much in your presentation. And the first thing that I thought of is maybe you want to also add the potential right to human decision making in the broad discussion of autonomous weapons. And I had several questions both about peacetime and so when it comes to peacetime, I was thinking, do you think that there's kind of maybe a law of weapons also that we apply when we think about the right to life, right? Because we do not assume that in law enforcement, the police can employ tanks, right? So maybe there's something in autonomous weapons that is closer to tanks than it is to regular measures to apply in law enforcement. And maybe it will be an easier path just to prohibit the use of actual lethal autonomous weapons in the context of demonstrations or whatever.
A complete prohibition.
Law enforcement. Maybe it should be a societal debate, but it seems to me that we can look at it as something that is uniquely military in nature. I have kind of Okay, when it comes to privacy, I don't really see how is it different than any question regarding surveillance or mass surveillance, right? We need it for the use of autonomous weapons, but we also need it to any targeting operation. So I wonder what is unique, what is different when you think about privacy, in the sense that you discussed it when it comes to autonomous weapons. The second thing is that, again, is about other cases. I really find problematic the dehumanizing argument when it comes to like distance from the battlefield. People raise it a lot, but I think that what's the difference between a drone and an autonomous weapons in this sense? Like I really find it difficult, and it also applies to what you said later on when it comes to like border patrol surveillance. Countries do it all the time with drones, and like what's the essence of the difference? I see the other problems with autonomous weapons, but specifically when it comes to dehumanization, I'm not sure that this is the case for like fighting jets and so on. And also about power differences, I'm not sure that the reality that we're facing demonstrate that this is the prime example of power differences. In the sense that we have like classical international armed conflicts, Russia versus Ukraine, both sides use technology all the time, but also in the current conflict in Lebanon, right, the use of drones by Hezbollah is all over the place. So in a way, this type of weapons, maybe not fully autonomous weapons, but some versions of this, or maybe in the future. So I'm not sure exactly how like power differences work there. Maybe it's more complicated.
Are you want to presentation?
That's it. Yeah. Okay. So I think that it's a really fascinating topic, and I think that we should explore it, and it raises so many questions about friendly fire, I think, generally. And I think that you are right to point how new technologies allows us to reflect about practices that we did not discuss, and I wonder to what extent does it affect the way that we think about combat operations generally. Friendly fire is a huge problem. There are like around 20% of the casualties are casualties of friendly fire. So what are exactly the implications if you deploy this human rights version? And I thought about several options here, and I'm not sure what I think about it. But so you mentioned the impossible burden. So where do we use this notion? One possible solution is to say the actual battlefield operations are outside this consideration of human rights. So because if we go down this route, every operation, the commander needs to think whether I pose unnecessary risk to my soldiers. This seems like a huge burden, right? If I choose to attack a house through a combat jet or ground soldiers, do I actually need to think to what extent it jeopardizes the right to life of the soldier?
That's what we do all the time.
Not exactly this. I'm saying maybe to some extent, but not as part of the legal assessment of the operation that is not like in the proportionality calculation kind of sense of like the military necessity. I'm not sure that this is how they think about it. I'm not sure like to what extent there's no right. Maybe in clear cases like Operation Human Shield in the South Park movie. Right? So this is where you need to think about it. But not. I'm not sure to what extent. But when it comes to autonomous weapons, right, in the development stage, this is not like the heat of battle. Maybe this is where these human rights considerations are easier to be taken into consideration. So maybe there's like a battlefield versus non-combat situations. I'm not sure. Maybe we should consider it when it comes. And then I think like what's unique about the discussion here beyond the strategy element, right? Do we actually do exactly the same? We want to limit unintended attacks, and this is exactly how we analyze autonomous weapons when it comes to the civilians of the other side, or is there something unique here about the soldiers. And in this sense, I think that maybe there's also a downside to this strategy, because I think that there are additional risks to the population of the other side from the complex weapon, from the deployment. And maybe if states are able to address all of the concerns regarding their own soldiers, and then we have litigation that approves the use of this type of weapons, but does not address the other concerns, it actually legitimizes the use weapon strategy. So thanks again.
Okay. How do we
go ahead.
Thank you so much for like several thoughts. I've jotted them down and I'll try to like crisply summarize what I and clarify like some of the aspects. So I think what is uniquely different about autonomous weapon systems, and when it comes to the development of these systems, that is actually one of my points of research, whether the development of the weapon system itself can be categorized as violative of IHL. So there are some scholars who have delved into, obviously, Article 36 of API saying that states have to necessarily ensure that the weapon systems, before they are deployed, comply with the principles. So if somehow we can establish that the weapon systems inherently cannot comply with these weapon systems, the development must itself be made illegal, which I think is a very credible argument. And I think categorizing them as inherently military is also logically makes sense, because if you want to categorize them for law enforcement operations, the problem is, again, states can modify them based on the amount of force they want to use. For instance, let's say you do not use tanks in law and order situations, but you use firearms, right? So now if they have a robot that only uses firearms, right, that's again an autonomous weapon system. But again, it's problematic with the rights we discussed. So I think that's a very credible argument. With respect to privacy, and the reason why I had included was, the problem really is the consequence of the privacy violation, which is unique with respect to autonomous weapon system. Let's say you have CCTV cameras all around, right? All the time, even mass surveillance. But the problem here is this is leading to something. So if there's a privacy violation, sometimes it's, let's say, especially in Indian context where the digital rights, although are entrenched in jurisprudence, but are not complied with more often. The problem is sometimes the discussions are more theoretical or academic in discussion, right? That how did you have my social security details for that, even if those are not used? The problem with the privacy implication here, and that's why proponents of abolition of autonomous weapon systems would want to focus on the privacy implications, because it has a real consequence in terms of loss of life, injury, etc., which is why I tried including it. We can obviously debate further whether it's necessary to discuss it specifically in the context, but just to broaden the human rights dimensions, this is also one of the segments. And finally, when it comes to the 2 points that you raised, the dehumanization of generally warfare and the power differences, the reason why I think it, and again, I'm looking at it from the context in which I've studied, let's say, the Kashmir context, right? The problem really that I see, let's say, is a real life situation where the Indian government deploys weapon systems without deploying any soldiers. The problem is twofold. One, it's easier for the government than to say that we are not militarily involved, we don't even have soldiers there. And second, it does not take into account the traditional value of life that you attach to combatants, right? Any combatants from either side. There is some value attached when it comes to combatants, right? Even though you want to prevent conflict in the first place, the fact is it happens, and once it starts, there has to be some value attached. And the problem that I find, and this is why I think I should have clarified in the presentation, the main issue is with fully autonomous weapon systems, where there's absolutely lack of any subjective judgment. You deploy them and then your hands are washed off. You have absolutely no. Those weapon systems are fundamentally problematic. Otherwise, you're right. States frequently use all kinds of weapons which are bizarre, right? And they also dehumanize conflicts. But the fundamental problem is absolute removal of human control. And finally, with respect to I'm giving very crisp points, but obviously these are very important questions. With respect to power differences, what I meant was, again, going to the Kashmir example specifically, obviously even if, let's say, the militants have recourse to some arms or ammunition, etc., The problem is that these will be very, if these are deployed, these will be very sophisticated systems, right? And once deployed, the power differential is such that one, the state, like I said, would not lose its combatants. There will be no loss of life. Second, it could also mean conserving the resources, right? So for instance, you need to, let's say, when it comes to soldiers, it's not just about life, but also resources. For example, if you see the Siachen Glacier, the Indian government and the Pakistani government, they have deployed soldiers at heights of, I don't know what, like 20,000 feet. And it takes literally like millions every day just to like deploy these soldiers there. Now just imagine if you have an autonomous weapon system right on the Siachen Glacier, right? The problem really is that one, if you're really trying to combat or like mitigate damage from the militants, they simply do not have access to the technology. Again, I'm not saying like because militants deserve that respect when it comes to autonomous weapon systems, but at a more fundamental level and even at a legal level, it is problematic because the rules simply do not foresee this. Which is why I would like to go back to the initial problem that you really need states to come together and like this, discuss what's the issue and what are the rules that we're going to operate in. Otherwise, the present rules, if you want to forcefully make an interpretation, you can have a presentation like I did. But the fact is, the rules simply don't foresee what's going on right now.
Tsvetelina, I'm sorry, I already have many questions, so I will just let you react and then to the people who already announced themselves, and then maybe we'll have to continue at lunch. Please.
Very interesting questions. So there's three main ones that I think come through. One of them is about this question of the concern with their own soldiers. The second one is what is unique here, and then the final point is about the normalization of the strategy. So on the first point, my sense is that concern over soldiers is constantly there. It is constantly there as a matter of general interest, even in these weapons in the first place. That's one of the main reasons why states actually want to have them. But it's also something which is a persistent concern in the law, sometimes in ways which are actually in accordance with what the law allows, and sometimes in ways in which I would say it's probably not allowed to take into account. So, for example, when you think of feasibility of precautions, in feasibility we have all kinds of considerations, including security and their own forces in the way in which states have interpreted this. But you could even say common truths should interpret the question of doubt in relation to the type of situation that a specific soldier finds themselves in. So to me, doubt is a question of status. So the security of their own soldiers wouldn't feature in the same way in which it features in feasible precautions. But to me, in the law, you already have it factored in. And I don't see why there would be a difference when we think of this in the context of the right to life. You're absolutely right that when we think of the design stage, something which is quite interesting here is that you can really outsource a lot of this at that stage. And in that sense, it can be a minimization of the burden in the heat of battle. But at the same time, you can say that one has to really look at what the system is doing and how it is performing. So there is also this question of how that feeds into your decisions to build that same type of system in the future. So I think that the burden is already there, and that's a good connection about that. The second one about what is unique and whether there is something different between parties of your own members of forces versus the civilian population. To me, it depends on how the system fares. So there are certain types of ways in which a system can fail, which are actually going to be equally applicable to you. Think about the sensor. That is actually just not a good sensor. It has a blurry camera, or for example, you have environmental conditions that have made it difficult to actually identify targets. That wouldn't really matter whether it's your own or someone else. There might be questions that arise, for example, with types of biases in the data in relation to a population that would be your own versus another population. And that might raise separate questions under what types of measures are actually necessary to be taken. And that would be a question that would be independent also on how you interpret the right to life, but also many of these IHL applications that might require these measures to be taken. Something that might be on the unique side in the Ministry of Defense in the UK, they were looking at principles for the responsible use of artificial intelligence in defense. And one of the big concerns that was quite prominent, I think in the first principle, was how members of armed forces will feel about their own loss of agency in the decisions of force. I'm not sure this is necessarily a right to life question, but it might raise certain questions around dignity and so on, about how a human being feels about this relinquishment of control. And then finally, on the normalization side, to me, these systems are being created, deployed, and it would be better to actually get some kind of review and at least have some finding on the practical measures that can be taken to make them safe, rather than to worry too much about normalization. They'll become normal one way or another, but it's better for them to become normalized with safeguards than without.
Okay, Shiran, please.
Okay, so I have a wonderful presentation, both interesting and related to mine. And I have one general thought, maybe for both of you, and one question for you. So I wonder, for me, as in researching the cyber warfare and international law of cyber warfare, I wonder if you had, in your presentation, I saw very similar gaps in when tomorrow in my presentation I will also present some gaps that are similar to the gaps you talked about in the AI area. So I wonder if you had a chance or thought about compare these two cyber warfare and AI. Maybe it's a question even for myself, because it's it's not the same field, but it can be related. So I wonder if you ever thought about comparing these two areas of warfare, and the question, your suggestions. A question regarding your suggestions that you had. What do you mean by strengthen international treaties, and what do you mean by collaboration of states? Because I'm asking it because I have again similar suggestions, not suggestions that I've done in my research. That I also thought that there must be collaboration between states in this area, because it's a new and emerging field. So I collected the positions of states regarding this issue, and show how these positions can use as an opinion jurist for customary international law in the future, of course. So I wonder, what do you mean by threaten international treaties, and what do you mean by collaboration of state? Maybe it's similar to my suggestion, or different. And thank you.
You said you also had a comment for...
No, the general thought that I had with the comparison between cyber warfare and AI, it's for both, and the question is for you.
Are we collecting questions, or can I?
I would say right now just...
So very interesting, because I think comparing them is important in that both are situations which have not been, which are not foreseeable under the traditional conventions. In fact, in my research, I looked at the Tallinn manual rules specifically, because I mean, those are detailed rules in that you have situations which are not foreseeable, but they have tried to compile state practice. So I think that's really useful. One obviously common element, like you said, is the digital. The both are at the end of the day technologies. And second, both are unique in that they've developed in the recent decades. In fact, autonomous weapon systems are still in very early stage of the development. So I would definitely, I have already researched about the rules that are operating cyber warfare, but I would definitely like to extend that further to see whether we can find some common ground as well. So that's definitely on my discussion and research. And secondly, when it comes to what do I mean by strengthening of the treaties? So more generally, when I was talking to few colleagues, what I noticed, and I have to see whether empirical research on this is already done, that we are signing and ratifying fewer treaties than we did earlier. I mean, you all can suggest if that's true or not. But generally, in terms of real obligations, what we could achieve in, let's say, the 20th century or the second half of the 20th century, this decade and the coming decade, I don't know if it's because of the hostility between states or generally, we're just not able to come to the table and discuss and ratify real treaties. So what I mean by strengthening treaties is, for instance, if you can see a clear gap in the Geneva Conventions, why not come with an additional protocol? You did come up with one when it was required. Why cannot do it again? Because then it would have the same binding power as other protocols do. And secondly, what I mean by collaboration between states is that, again, that states are reluctant to discuss this issue. One, because they know the possible answers, right? They know how, let's say, smaller states which do not believe in, let's say, for example, Costa Rica, they don't have a standing army, right? What are you going to say? They don't even have personnel on the field, and now you're talking about autonomous weapon systems. So clearly, states who are developing these weapon systems know the answer to the question of whether they should be deployed. So my guess is that at least if they come on the table, they can at least assure the other states of the mechanisms that they're going to use, the situations they're going to use, that they're going to use it in specific contexts. So that is what I mean broadly about collaboration. Not necessarily legal collaboration, because like I said, a binding agreement seems far. Obviously, that's the priority. But if that's not possible, at least a discussion on the table so that you have some statements coming from the state that you can later utilize as maybe state practice or evidence of potential state practice.
Thank you. So, did you want to comment on that?
I would love to, unless you told me to.
Okay. No, is it okay if I go on to the next question?
Yeah.
Okay, Laura.
We can talk.
Yeah, I'm sorry. There's just so many.
Afterwards.
Yeah, I think that we will have to. Yeah, Laura, please.
I have a question for you, Rahul. I didn't quite understand the argument with minimizing harm when it comes to autonomous weapon systems, because I think that when it comes to targeted killing, that it would minimize it compared to the conventional weapons that we have now. It would minimize harm. I didn't quite understand.
So what I meant by, and in fact in my presentation, I slightly highlighted the benefits as well, right? So obviously one of the benefits that is proposed is that you would only if the system is deployed properly, they would actually use only force that is required. The problem with, and why I think it fails the test of minimizing harm is the lack of subjective assessment, right? So for instance, like I was constantly emphasizing in my presentation that obviously military commanders, they make decisions which later in hindsight are problematic, but at least they take a call based on that case. There is a case-by-case analysis. And I think that is inherently problematic with an autonomous weapon system, because you cannot foresee every situation. It is based, we have to remember that much like any other AI system, they are based on data for specific situations, and then they repeat those things time and again, right? So inherently, they cannot have a case-by-case analysis, no matter how much you emphasize on context-specific use of force. So that was my argument about their lack of ability to minimize harm. They just cannot foresee all situations. And my test is that all situations either have to be foreseeable, because if there was a human commander, let's say, in place of these autonomous weapon system, they would take the call based on something, maybe erroneous judgment, but at least they would take a call on something, and therefore it would not be a completely out of thought situation. So that's my problem with it. Yeah.
Okay, thank you. Then you use, please.
Yes, I have a short question for both of you. Actually, it's kind of similar to Laura's, actually. And I was just wondering about the collateral damage estimation methodology. Because of course, we were talking about proportionality and necessity and the measures that have to be taken. And I was just wondering, do you have maybe a concrete example? Because I was thinking about maybe an algorithm, but that's kind of vague. And like you said, cameras and sensors can be skewed. So you maybe do you know anything about concrete example or something, or any state that already proposed something?
So if it's a question to both of you, maybe just
you can go ahead.
You want to go?
I do have the use of artificial intelligence in the identification of persons. Maybe something just happening. Again, I'm going around that label, whether it's an autonomous weapon or not. But then the question of collateral damage assessment methodologies, to me, all of these are just questions about, first of all, what you actually put into that assessment, which is a question of legal interpretation, and whether it's also about reverberating effects of your attack. And there is the question of the reliability of the assessments that you're making. So to me, these are just traditional questions that arise in any other context. I don't see something that is specific to autonomous weapons in the context of how you determine excessiveness of collateral damage. I think the only question which is really interesting here is, again, the reliability and the safety of these algorithms that you deploy to make sure that what you're actually doing is an accurate picture of reality. I don't have an example for a specific state that is using these methodologies, but I don't see a question from that.
So there was an edited book actually. I think it was maybe edited by Boothby or someone, which has actually collection of articles specifically on the technical aspects of these weapon systems. And what I found, and there are like several states that are developing it, right, ranging from China, Israel, Russia, UK. And when it comes to collateral damage, what they're taking into account is the previous situations. And one of the articles actually discusses about the previous conflicts. The problem again is the reporting of it, right? Because they're based on, and I understand like concerns with algorithm, etc. But specifically when it comes to, let's say, the proportionality analysis, because it's based on previous conflicts, the narrative that is deployed or employed in these articles, that is like fundamentally problematic. So for instance, let's say you're feeding the information from, when it comes to China, from a state media source, right? These are the conflicts, this is the damage that was caused, this is the damage that should not have caused. The problem is of narrative. And secondly, I think, and this is fairly like in my opinion, like very problematic, is that of course, like other rules also necessitate a human involvement, but more specifically with proportionality, human involvement, because by definition, if you want to like limit like collateral damage or limit excessive damage, you need a human analysis. I'm not saying that's not required for distinction, but at least when it comes to distinction, literally you interpret the rule. If the weapon system is capable of distinguishing between, let's say, civilians and combatants based on dress, whatever, etc., at least that's possible. That's plausible at least.
Yeah. Sorry. Yes. And if it's okay, I will give the unknown, and then Magda, if we have time, just so, because you can still ask at lunch. So unknown, please.
Thank you, and I hope you will enjoy lunch. I'm sure it's going to be delightful. I think I'll be very brief. I think that we should really be careful that we don't situate ourselves in the same position. Of course, this crowd is well aware of it, of the debate around the legality of submarines. People thought that submarines will dramatically change the situation, and now we think differently. And within that light, I want to suggest ask three main questions. First of all, I don't think, and this is a question for all, I don't think we should so clearly and easily let go of human dignity. Why? Because weapons do not only kill. There are various types of weapons, and if you look at what's going on now, right now, as we speak, in the border between North Korea and South Korea, they use non-kinetic weapons. They use voice, sounds. You can use cyber weapons. You can use all kinds of weapons. Some of them could be fully autonomous. In fact, it's easier to make them fully autonomous, and they make life really miserable. They don't kill, but they make life really miserable, and they treat people just like you treat insects. So I wouldn't let go of the dignitary element so fast, especially when it comes to autonomous weapons. The second is, as Yali, I'm totally not convinced about the notion of fairness. Why? Because precisely because these weapons are so sophisticated, it's not difficult to actually use relatively simple devices that may disrupt them. So actually, it does all kinds of weird things in terms of the balance of fairness, to the extent that we even think that war should be fair somehow, that there should be a fair playing field. I'm not sure that the superpowers will agree to that. But even if we do agree to that, as a measure to convince us not to go to war, then you can use all kinds, sometimes very simple devices but the starting point, I think, is what I think Laura's asked a question or something. I think we should always ask ourselves this: are we better off than the current situation with autonomous weapons or not? And here, I think we don't know, because fully autonomous weapons were not deployed. And I don't think there is any state that seriously considers in actual war, to deploy fully autonomous weapons simply because the technology is not there yet. So we don't really know. But I think it could go both ways. I think that we might be way better off precisely because, and this goes to the second presentation, which I think was also wonderful, I'm not sure it's less investigable. We can investigate it. Actually, the idea that there's a black box there is right, but compared to what's going on currently, it's very difficult to investigate who did what to whom during war, and it's. But if you have a technology and everything is recorded, it's recorded for the weapon designers. They want to improve. So everything is fully recorded and you can investigate, you can improve it. So actually, we can actually know much better. The last point I want to make, it again goes back to the question that was already asked, and that is a question of intuition and judgment call and all that. Because these are learning systems, the technology is that true, you start with previous, but you always keep updating the data. I'm not sure that human intuition or the intuition of the autonomous weapon necessarily goes one would kill less than the other, so the judgment call of a human being may be motivated by revenge, by hatred, but by all kinds of things that you cannot rule out, whereas you may want to reconsider the autonomous weapons. I'm not saying we should. I'm just saying we should be more careful before we decide on a categorical ban.
Thank you. Amnon, you want to react?
Yeah, I have to. I think it's a very good point about the question of traceability and investigative duties. I mean, in one sense, you can think about black box as a recorder, the way in which we think of this in the civil aviation space. And in another way, you can think of a black box as something which is not necessarily understandable in terms of input, output. And you're correct that maybe we'll know better what happened because of that first function. We'll see that person X was struck. But maybe we don't know why it happened, which is the second type of black box, which is that input-output question. And to me, there may be something in the existing standards under the right to life and investigative duties that might suggest that perhaps we need to have at least some degree of traceability of outcomes to be able to know the why and not just the what actually happened. But this, just a very small point which kind of relates to this entire conversation, which is that question of gaps and whether these systems are prohibited, if they're not. I don't see anything within existing law that says that you can't have autonomy in different targeting functions. I think it's a question of what type of autonomy, how is it actually regulated, what are the safeguards. But that then brings the question of that gap idea. And to me, it seems like the law applies. And we have law both in the cyber context and the context of AI. And then your idea of a gap depends on your normative sense as to how far the law should go. But to me, that's a separate discussion to the discussion of what is the law, what are the types of obligations that we can currently argue. So this is the only one that I would maybe push back a little bit on in terms of all of this is unlawful or all of this is problematic.
Yeah, very quickly.
Very quickly.
Yes, thank you so much. I've jotted down the 3 broad points and will keep that in my mind when I research further. I'm really glad that you thought the dignity aspect is important. I limited that in my presentation so that it doesn't become philosophical, etc. But of course, that's very important, and I'll definitely look into how we can inform that analysis into other rights, the right to life violation, etc. Just very quickly on the question of are we better off than the current situation? Maybe. If we have these weapon systems, maybe they'll be better off. The only problem is one, I don't think myself competent enough to go into the technical aspects of these weapon systems and how exactly they'll be developed to ensure that they actually minimize harm. So that's something that I have to make myself competent in. And then if the analysis is that, okay, you can have a situation where actually humans should minimize their involvement in specific situations, then maybe yes. So of course, I'm not for a categorical ban, but I definitely mentioned in my presentation that unless states are willing to come together on the table, moratorium can be placed until then.
Okay. So I'm sorry for wrapping up here. We have a logistical problem to solve.
Lunch.
Lunch, plus you need to check out.
Yes.
And so, unfortunately, I will have to ask Magda to ask the questions at lunch, the same for Sif, and also
Around the table.
Yeah, just
You should all sit together.
yes, yeah. You can have a fruitful discussion during lunch. And but thank you for the two very interesting presentation. It's always better to stop when there would be more instead of when it's running out. Thank you so much.